Good afternoon, everybody. Thank you for attending our workshop today. Actually, I think it's just right on 12 o'clock, so I don't know it's morning or afternoon, but anyway, good afternoon to everybody. All right. Just in a few words, I would like to mention to you what is the today presentation is about. It's about the labor agreements and solving the skill shortage under the skilled migration stream. Next slide, please, EJ. Just very briefly about our company and about myself, maybe, I have established No Borders Migration in 1998 as a migration agent, and then I completed my legal studies, and then we have become a law firm, and we have 4 distinct divisions: employment, commercial, property, and migration law. What we do, okay, we're providing legal services for corporate clients and individuals. And why we do what we do is my biggest motto is, and my absolutely lovely idea and intention, to changing people's life. And in a corporate world, to ensure that people still profitable and they have no problem recruiting their staff. Next slide, EJ, please. Okay, the key discussion today will cover the business impact on ongoing skilled worker shortage, understanding the labor agreements. I think that's a little bit of a mythical area. Labor agreement versus standard business sponsorship, why labor agreements exist, and when they are used, and who are used by, okay? Businesses best suited to labor agreements, and how labor agreements can support your business. Okay, just from the outset, immediately, I would like to say some labor agreements can take a long time, so you may wish to consider to start the process as soon as possible if you foresee the growth of your business and you would like to retain overseas skilled workers. Next slide, EJ. Okay, I'm sure you are all aware of the opportunities that are existing regarding, employer-sponsored visas. And we have a couple of distinct visa classes and sponsorships. And this slide talks about that exactly, okay? So we have initially the temporary visa stream, which is skills in demand, the SID visa stream. And I am sure that some of you may come across with the different categories within the SID stream, because we have a core skilled occupation list, and we have a specialist occupation list. And just remember the main differences. Some occupation is on this list, some occupation is on the other list, but the biggest distinction is that under the specialist list, the minimum salary is $140,000 plus superannuation. Under the core skilled list, the minimum salary level at the moment is $76,500 and blah, 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 a couple of dollars as well. So that's the key difference. But all this occupation, what's are on this list, can be used to sponsor your overseas staff. Okay, I mean, some corporate, maybe CFO or managing director or sales manager, they may earn $140,000, $180,000, $200,000. So, and they are on the special list, then they can be sponsored under this stream, okay? Now, just very briefly, the key elements of the temporary visa stream is, what you require to do: standard business sponsorship, nomination of the occupation, and the visa application. So if your business doesn't have a approved standard business sponsorship, that would be the first step. What is the requirement? You must demonstrate that your business is lawfully operating in Australia. You possibly haven't been bankrupt. I mean, if there were previous activities where the organization was bankrupt, then it has to be explained to the department. But usually, the department like to work with businesses that are lawfully operating in Australia. Required, ABN registration, requires financial records for the last 12 months, and organizational chart. Why the organizational chart is important? To ensure that your nominated person and the nominated occupation fits within the business, okay? So that's just in a very brief nutshell, okay? There are other stuff what may be required, also, what type of structure the business has, then we would require different documentation, but I am not gonna visit that area. Once the sponsorship approved or has been lodged, you can lodge a nomination, and the nomination is nomination of the position, okay? It's not the visa applicant, it's nomination of the position. And the position, say, I use an example, a carpenter, so your business profile is construction, and you would like to employ a carpenter, then the nomination is for carpenter. Then you require under the nomination a labor market testing, which has to be done for 28 days. Sometimes our clients are asking us, would Gumtree or Facebook or LinkedIn sufficient because they advertised on those platforms? Unfortunately, for labor market testing, those platforms are not accepted. So accepted platforms, the Seek, the Career One, certain job boards of certain industry bodies, recruitment companies offering labor market testing, and they can advertise and they can prepare the reports. Some of the countries, won't require labor market testing, and some of them, Singapore, Malaysia, Peru. I don't know why Peru, but that's also on an exemption. China is on an exemption, and a number of other countries are exempt from labor agreement for labor market testing. And what is that means? That the person who are nominated in this position from those countries, okay? So that's something important. Otherwise, 28 days advertisement required, and a report has to be prepared to the department why is your candidate is the most suitable for the position. And certainly the candidate must apply for the job advertisement. Even we like to recommend, even if the employee is already working with you, maybe for 6 months or 8 months, and you're very happy with that person and you're offering him a possible sponsorship, then you still require to advertise, and the person still required to apply for the position. So that's the key element of the nomination, one of the key elements. The other key element is genuine position. Okay, so the department wants to ensure that the position hasn't been created to facilitate someone's visa application. So it's within the company's structure, within the company's profile, okay? At my humble beginning, many, many years ago, I went up to the Department of Home Affairs, and someone talked to the department, the officer, and said, we have this family member in Yugoslavia. At that time, it was the old Yugoslavia. We would like to sponsor him. And, we have a carpentry business, and the guy is a air condition mechanic. And of course, the department immediately said, look, this is not in the profile of your business. You cannot sponsor that person. So it's always very important that the position fits within the organization. The other key element is to the nomination is nominate the salary level. And as I said at the beginning, $76,515, or I always say $76,000 or $77,000, just for the sake of easiness. And also remember, you can use the minimum salary prescribed by the department, but the department has other avenues to assess the genuineness, and that is your position meets the market rate. So if a market rate is above the $76,000, $77,000, then you certainly better to offer that higher salary, okay? Sometimes, again, carpenter or construction worker, you don't use $76,000 if a carpenter earns $85,000. Also, if you employ other carpenters, you can use one of the other carpenter's salary level. And if that is $78,000, then you can nominate that salary, even if the market rate is higher than the $78,000, because you're already employing someone in that position who is an Australian citizen or permanent resident. So these are really the key elements of the nomination, and these are, very relevant to your business. The other requirement is the visa application, and that depends on the visa applicant, what type of qualification, what type of work experience that person has, English language requirement, does that person meet the minimum level 5 English requirements? Of course, if they are from certain countries, there are no English language tests required, but otherwise everybody requires an English language test. Sometimes people say, oh, but I studied, in the language of English, and it's not accepted, okay? It has to be an English language. It doesn't matter which immigration approves, but it has to be one. And the English test usually valid for 3 years. So if someone done it in 2024, that English language test is still valid, so you can use that for the visa application. Family members can be included. But once you include a family member, there is a statement has to be provided to the Department of Home Affairs that you are extending the sponsorship to the family member. What is that means? That you don't sponsor that person and you don't require to offer them employment, but you are aware that the partner is existing and you're supporting the application with the partner included. All right. So these are the 3 key elements of the 482 visa stream. Okay. Now, if we just go around on the top, description, we have other temporary visas, okay, which is the regional sponsorship, which called subclass 494. And very similar, you require sponsorship, you need to nominate the position, and the person need to apply for the visa. However, this visa category requires from the visa applicant a minimum 3 years full-time or equivalent part-time work experience in the position what you are intend to employ them in, and minimum level 6 English. Under the 482 stream, minimum level 5, under the 494, minimum level 6. But on each component of the English language test, they require to meet the level 6 requirements. Also, family member can be included. And your not so much your head office or your offices has to be in a regional area, but the work what needs to be done by the nominated employee has to be located in a regional area. Like if you have a head office in Brisbane or in Sydney, then and the work has to be done at Coffs Harbour or on the Gold Coast, then that is certainly a regional area, and you can nominate the employee in that area. The visa provides also a permanent pathway after 3 years, and that is where you can weigh it up, if you are in a regional area, are you going to do a normal 482 or are you going to do a 494? Depends of what is your preference or what is the employee's preference. Neither visa category offers, permanent residency. So, there are really, I don't see too much of a benefit, but sometimes occupation can be, different what's available on the 494 visa stream than what's available on the 482 visa stream. So maybe that's something which is up for consideration. Okay, so that's again, as I said, a temporary sponsored visa. And one more element what is required under this visa category is a regional certifying body approval. which each regional area has their certifying body, and they have to approve the application first. Then you can lodge the nomination with the Department of Home Affairs. Okay. Now, the labor agreements are, in a sense, approved sponsorship. An approved labor agreement is an approved sponsorship. So if the company has an approved labor agreement, that company doesn't require an approved sponsorship as well, okay? So I am going to talk more in details regarding the labor agreements. So with your permission, I would like to return back to the permanent part of this employer-sponsored visa stream. And the permanent part is the 186 visa stream, okay? And there are two distinct streams under this visa category. One is the direct entry and one is the transitional. And the direct entry stream is sometimes, I find, when you recruit someone from overseas who is a higher caliber, in a higher position, giving up, 10 years experience overseas, giving up a lifestyle overseas, but he's very skilled and fits in your company, and you would like to retain that person, then sometimes they would like to negotiate a permanent direct entry visa stream. But I'm usually talking about here the high salary, $180,000 to $150,000 executives and corporate clients. So it's available to come to Australia under the direct entry permanent stream. What is that means? That when they get the visa, they will have immediate permanent residency, and sometimes for the education of the children, especially if they are university candidates, like maybe they are 17 years of age and they would like to go to university, they may prefer to get this visa, okay? The processing time is lengthy, and it doesn't matter what position we are nominating someone, the processing time can be 12 to 16 months. Sometimes can be faster, depends, what standing of your company has with the department. Are you an accredited sponsor? So it depends on many things, but at the moment, that's thumbs up about 12 to 16 months, the processing time. And it means that once the person gets to Australia, he's permanent resident, and, he would get Medicare, he would get, as I said, entry for the children to schools, many things, okay? And they can buy property. For some high-profile candidates, that's also very important that they can, when they relocate, they can buy property. The other stream is the transitional stream, which means transiting from the 482 visa stream to the permanent residency, to the 186 visa category. The requirement under this visa is that the employee worked 2 years for the nominating sponsor, okay? And must demonstrate that the salary has been paid as it has been prescribed, okay, or what the nomination has prescribed at the initial time when they applied. Then just 1 second, I turn my phone off. Okay, I have to. Yeah, and once the so it would require the pay slips, the superannuation payments. So really has to be demonstrated that the employee worked 2 years under the temporary regime. Very important that at the last week of the second year, the employee will be eligible to apply for the permanent residency. Why is that important? Because when you nominate someone in a temporary visa stream under the 482, you can choose for how many years you would like to nominate the person. And it can be 2 years, can be 3 years, can be 4 years. If you nominate the person for 2 years, then the visa applicant and the organization must make sure that the visa applicant commences employment immediately when the visa is granted and doesn't take unpaid leave during the 2-year period. Because if the applicant would take unpaid leave, they would miss out on the last week of the second year to apply for permanent residency. So sometimes it should be considered to nominate a candidate originally for 3 years. The only requirement is that you have to pay the SEF levy, Skilling Australia Fund contribution for 3 years, which can be an extra $1,200 or $1,600, depends on the size of the business, what you require to contribute. But it gives you a peace of mind and gives the peace of mind to the employee as well, that they would be able to transit for permanent residency. I think to secure someone for a long term, it is extremely recommendable to sponsor them after the 2 years for permanent residency as well. So you can usually have an employee for 5 years. It doesn't mean that the employee cannot leave you, okay? So the 482 visa stream or any visa stream is not a guarantee 100% that the employee cannot leave the employer, because yes, they can leave and find another employer, but that's not that simple, and they would need to transit over to another sponsorship and another nomination. But usually if you find the right candidate, the candidate would be able to the candidate would be able to, stay with you, and you can have the benefit of a long-term employee. So that's in a nutshell about the different employer-sponsored visa stream. And now I would like to go to the labor agreements, okay? And we have distinct labor agreements. We have the company-specific one, the industry-specific one, DAMA labor agreements, and on-hire business labor agreements, okay? EJ, can I have the next slide, please? Okay, so as I mentioned, first of all, I would like to probably just mention what are the key benefits for an employer to have a labor agreement. And different rules applies for on-hire business, and different rules apply for, your company, which directly employing the employees. But the key benefit is that you can sponsor people in different occupation to the prescribed list, okay? So if you have certain occupation, what your company would like to nominate people in that is not on a 482 stream, then you would like to consider the labor agreement, because that gives the flexibility to employ them in a different occupation, okay? But those occupations must be in skill category, and like under the Australian ENSCO, and I'm sure you all heard about the ENSCO description. Under that description, you must employ the people usually up to skill level 4. In some instances, skill level 5 is accepted, but usually it's in a regional area, and in very rare occasions, the department approves a company-specific labor agreement for those occupations, okay? But that gives the flexibility to employ people in a non-existing occupation, what is not on a skilled list, okay? Flexibility as well to have the employee over 45 years of age if they want to go for permanent residency. Flexibility to negotiate the salary. The negotiation is really limited to up to 10% below the prescribed TISMIT, okay? So that is very important. You cannot negotiate under the labor agreement for a lower salary. I'm only talking about here for the company-specific labor agreement, but each labor agreement gives you the opportunity. Next slide, please, EJ. Okay, industries, who are using labor agreements, and I really don't have the full list of clients who are attending this workshop, but if you are from nursing and aged care, agriculture and horticulture, the meat industry, hospitality and tourism, in this area, mainly you can have five-star facilities that would like to employ waitresses and barmen and all that from overseas, they can have a hospitality industry-specific labor agreement. The automotive industry, there are some occupation that maybe not on a 482 visa, but I think that's not so relevant these days, but previously it was because spray painter were not on a list, okay? On hire labor agreements and advertising company labor agreement, and of course the aged care, okay? So next slide, EJ, please. All right. So initially, I would like to just mention about the company-specific labor agreement, which is really, how can I say that? It is very liberal because there is no prescribed rules as you have prescribed rules, for example, for an aged care labor agreement. So you negotiate as a company with the Department of Home Affairs the different rules which can be then secured in the labor agreement to sponsoring overseas candidates. Each labor agreement would require a labor market testing, where you would require to demonstrate that you cannot locate Australian skilled employees for the position to fill, okay? And in a company-specific labor agreement, you require a lot of documentation, which gives information about the business history, the financials of the business, the future plan of the business, why you would like to recruit 10 new candidates, where is the business, growing, and what would be the financial benefit to Australia and to the company itself. You require to seek recommendations from industry bodies who understands that your industry is suffering of skill shortage. And as lawyers, we would require negotiate the agreement or having a discussion with the unions, and they have to either they're going to approve the request or they say, no, we're not approving it, but we still require a communication from the union to demonstrate to the department that we have met that requirement. Then we would require the salary nomination. As I said on that, the labor agreement, you can nominate lesser salary, but not more than 10% below the TISMIT, which means maybe $69,000, and this is relevant for certain occupation. Now you can imagine if a candidate or your business has a requirement for, say, cleaners, right? Then they are maybe not earning $75,000. So you would like to negotiate a lesser salary, okay? But you cannot negotiate more than 10%. There is also English language, if someone, if you do a cleaning or you're working as a cleaner, I'm just picking this as an example. So if you're working as a cleaner, you don't require really high level of English knowledge. So that can be negotiated, in a labor agreement, maybe 4.5 overall, which is a very basic English. You want a candidate when you employ them to speak a basic English because otherwise you can't communicate and can't instruct them what work they need to do. But that's not a high level, okay? So and age, as I said, can be negotiated. Age is really important when they would like to transfer or you would like to nominate them for permanent residency. The 482 visa stream doesn't have age limit, okay? So you can employ someone when they are 60 years old under the 482 stream, all right? But usually the age limit under any labor agreement is about 55, okay? So that's usually pushing the rubber band, okay? But that's all can be negotiated. And once you provide all the evidence and, as I said, it's quite tedious, big documentation, what we require for the company-specific labor agreement. Once you provided this, the department will assess and the department can approve, maybe they ask you to negotiate further, provide further evidence, or they can say, no, we're not approving it. Okay? And the processing time can be lengthy, can be minimum 10 months, but can be 2 years. So it is important that you prepare yourself if you see the growth in your business, that you are, ready and you have a labor agreement in place when you require that. And this is acting as a sponsorship. So once you have an approved labor agreement, you go and lodge the nomination and then the visa application. Okay. And any labor agreement is like a standard business sponsorship, is valid for 5 years. Okay. And during the 5 years, you can vary the agreement. You might start with 5 candidates. Okay. And then later on, you would like to employ another 10. But remember, the department has introduced new processing. You only can vary the labor agreement once every year. Okay? So you really need to think it over how many people you would require, because if you would like to further extend it, you only have one chance in a year. Okay? Previously, we had a number of opportunities to make a variation. Okay? But that's just on this, they just brought it out very recently, once a year. Okay, then we have the industry-specific labor agreement, which, as I mentioned, all those categories. And one of the key areas, what we would like to talk to you about today, is the aged care labor agreement, which is very topical. But certainly we have the meat industry labor agreement, and that's all based on prescribed rules, and the department has the templates for that, has a specific requirements. Okay, so that's different. And the industry labor agreements can be processed much faster, in some instances 4 months, some instances 6 months, and depends on your documentation, what you can provide and how long it's going to take for the lawyers to prepare the submission. Okay, then I would like to talk about the designated area labor agreement, and that is by prescribed locations. Okay. Recently, I heard that Queensland is working on becoming the whole state becoming a DAMA approved sponsor, but that's not in force yet and not in place yet. Like as South Australia is the whole state is a DAMA approved opportunity. Western Australia, okay, different categories they have under the DAMA in those locations, but the whole state is available for the DAMA sponsorship. In Queensland, we have Townsville and Cairns at the moment that is approved under the DAMA labor agreement. And really very good, because the local government is really very flexible and very committed to you as an employer to facilitate, your need to employ these people. I mean, in North Queensland, usually, the tourism industry is very much, supported. In Townsville, very much supported. Construction or sugar company, or construction, I mentioned that. So very flexible, okay? And what is that means? You do the same thing as you do under the company-specific labor agreement, but you're seeking an endorsement from the approving body, which is usually the council or the business enterprise in Townsville, or in different locations, like in South Australia, they have each location called differently, but usually is the council, one of the council's department, which is approving the DAMA labor agreement. So you seek the endorsement, and under the endorsement, you have to provide all those documents, what I listed for you under the labor agreement: financials, need for the employees to be employed, business plan, labor market testing, how many employees you have, organizational chat, all that you have to provide and seek the endorsement. Once the local body have the endorsement, and they also have specific occupation list, okay, and specific requirement what the visa applicant must demonstrate for the approval of that DAMA labor agreement. I am not going to go there, because if you require any support from No Borders Migration, we are here to support you and give you a very detailed list, but you require to meet those requirements. And once they approve and endorse, then you can apply as an overarching labor agreement under the Department of Home Affairs for the approved labor agreement. So this is also a labor agreement, so you don't need sponsorship, but first you have to seek the endorsement, and you provide the details of the endorsement when you're applying for the labor agreement with the department. Processing time to get the labor agreement approved under DAMA could be 4 or 5 months, okay, is far less than the company specific one. If you are in a regional area, this is very flexible, and we really do a lot of DAMA applications and endorsement for our clients. So that is in a nutshell what a DAMA labor agreement is. So, and just remember, every labor agreement is a sponsorship, just negotiated for different occupation with different rulings, okay? EJ, next one, please. Okay, so now I would like to talk to you about the aged care labor agreement, okay, which is one of our key topic, okay? What is the requirement on that? Then now maybe I put up my glasses because there are some specifics here, okay? So first of all, why did the department introduce this flexible aged care labor agreement? Because, the industry, especially, when a lot of aged care facilities, we're getting older as a society, I must say, and dementia and the different, illnesses, what, for elderly people exist. The department just cannot the Australian government just cannot support, these facilities with local workforces. Okay, so that therefore they implemented this new labor agreement under the industry labor agreement. Okay, so and also remember high turnover of staff, and I'm sure if you one of you or a couple of attendees working in this industry fully aware of the high turnover of staff, underpayment, they are not happy. It's a lot of issues, okay? So once you have a sponsored workforce, then it's more likely that they're staying with you until the sponsorship is in place and their visa is valid, okay? So who can use this? That's very important, okay? What type of organizations? Approved residential aged cares, okay, approved home care providers, and providers delivering government-funded aged care, okay? So very important that you are licensed as an aged care facility. Sometimes simply NDS providers would not come under this ruling, okay, because you have to be approved as an aged care provider. Again, what are the benefits? Because that's always important for us as employers. What are the benefits for us? Reduced English language requirement, only 1 year work experience from the visa applicant, okay, and certainly pathway to permanent residency for them. But for the employer, really, the major issue is the salary level, because under the 482 stream, if they are disability support workers or disability, there is another word, disability service officer or family service provider or whatever other heading, community worker, their salary is $75,000. Now, not every employer able to pay that salary. Therefore, when you have this approved agreement, the minimum salary level is around 51,000, 52,000. I mean, it's in the regulation how much you have to pay exactly. I think it's 51,200 or something in that vicinity. But, and here is the but, you also need to meet the market rate. So if the industry pays $58,000, because you have to provide the labor market testing under this stream as well. If the salary level is $58,000, then you need to pay that, okay? But you don't need to pay $76,000. And these are all the base salary levels, not including superannuation, of course, okay? And as you can see, occupations in this labor agreement category are aged and disabled carer, nursing support workers, okay, personal care assistants, okay. These are the three main categories. Next slide, EJ. Okay. What makes it different from other labor agreements? Occupations, you know, what type of occupation is a personal care assistant, okay, or different carers, you know, we have that, which again is not on a skilled occupation list for a 482. English language requirements, they may negotiate it out for level 4 or basic English language requirement. Skills and qualification, you know, they can have basic qualification and just 1 year work experience, you know, and age limits for the permanent residency. Okay, but that age limit is usually for each labor agreement, you know. And the requirement here as well, we require to negotiate this again or start to work with an MOU, which is a memorandum of understanding with the union. And this is where we as lawyers require all your documents, labor market testing, profile, everything. And sometimes it is beneficial if your business has already been an approved temporary sponsor, or you have that previously with, you know, the Department of Home Affairs, and you have a good standing with the department. I always encourage my clients to have a standing with the department because it's much easier to get these agreements approved once you have a name with the department. But the MOU is Memorandum of Understanding. Us lawyers would negotiate with the union. There are 3 different union bodies, you know, there is the midwifery, there is the health support, and there is aged care, something. Okay, I have the list so I can provide it to you, but these are the 3 different unions who we require to seek the approval. Depends on what occupation you're nominating, okay? EJ, next slide, please. Okay. And finally, briefly, I would like to mention the on-hire labor agreement, okay? The difference between the labor agreements, company-specific, DAMA, all what I have been talking about, and the on-hire labor agreement is that an on-hire labor agreement is valid only for the occupation that are on a skilled occupation list, okay, which are on a 482 skilled occupation list, because you are not you hiring these people out to the end user, but you are the one who is responsible to pay their salary, okay? So what is, you know, recruitment businesses, labor hire companies, and businesses where, you know, the core profile is recruiting and providing labor force, okay? And under the on-hire labor agreement, the company is the sponsor. As I said, the company, the on-hire company is the company which is paying the salary. Therefore, they become the direct employer, okay? Even if the end user is using the services. Overseas worker must be employed full-time, okay? So that's your responsibility as a labor hire company. The worker is then assigned to the end user, and the worker remains on the on-hire company's payroll for the duration of the employment. Now, an on-hire company can move the employees around, but in the same occupation, okay? Usually under this stream, all the 482, only the 494, which is the regional stream, the employee has to work in a regional area. But all the other visa classes, the location is not so important, okay? Position is important, that they're doing the same work what they were sponsored for, and the salary level, that hasn't changed, okay? Now here, the department try to minimize the exploitation of overseas people, and therefore it is an important aspect that the employee receives the salary throughout the sponsorship. And you as an employer, either as an on-hire or either as a direct employer, you must avail yourself for any monitoring of the Department of Home Office during the period of the approved nomination and the visa applicant visa grant, okay? The difference with the on-hire labor agreement requirement and the normal one, then in this instance, the salary level has to be 20% above the prescribed TISMIT. So $76,000, you have to pay 20% extra. And that's what you need to demonstrate in a labor market testing. Okay, so 76, that's about another $16,000 roughly to the $76,000. So you would require to pay around $90,000, $92,000 for the candidate as a base salary if you are hiring them out. So that's maybe for consideration in a labor hire service, that you really focusing on recruiting people where you know that you might be able to hire the person out for $120,000, and the people will be employed by the end user. Okay, that's very important. The two distinctions: occupation must be on the skilled list, on the SID list, specialist or core list, and 20% extra base salary, okay, to the TISMIT. Next one, please, next slide. Okay, key benefits of labor agreements, okay. Secure long-term employees, that's always very attractive. I mean, when you are sponsored and you're working for a good company, I mean, if there is an abuse of employees in a workplace, certainly the employee has the right to move around. But if it's a very good relationship between the employee and the employer, this offers you a long-term opportunity to have that skilled worker. And sometimes, when you bring in skilled worker from overseas, they are maybe more highly skilled than some of the Australian employees in the same area. Access dedicated and skilled labor, I just mentioned that. Flexible workforce mobility, cost-effective hiring, as long as the salary is above the TISMIT, you may, sometimes when you employ local candidates, they might negotiate because another company would offer them $10,000 extra. That is not a requirement under the employer-sponsored stream, You just need to pay either the market rate or either the TISMIT level. And build a reliable global talents. I have many people who are recommending their family members, or, they know someone else in their country. They might recommending those people to other employers. So, you can really benefit from a global workforce. Next one, EJ, okay. Employer eligibility, who can request a labor agreement, okay, as I mentioned before, genuine labor market need, so the labor market testing, compliance with workplace laws. it means your business is lawfully operating, and sometimes you can have, maybe you had a fair work issue at the workplace. That doesn't mean that you can't use this system, because that matter has been resolved. You make people redundant, but if there is a valid reason why those people were made redundant, then there is not a limitation, okay? But certainly, if you make 15 people redundant, that's maybe raises alarm bells for the Department of Home Affairs. Financial capacity of the business, that's why we require the financial documentation and financial capacity to pay the salary of the applicant, okay? So a visa applicant, so that's important. Industry significance, like some of at the moment, construction industry is screaming for, overseas employees, all type of occupations, in that industry. Actually, I think Western Australia is supporting the businesses with giving them some bonus payments. So yeah, it's all industry specific, okay? Long-term workforce strategy, as I mentioned, visas can be for 3 years, can be for 4 years, and you can retain those employees even after that. Myself as an employer, I have one of my employees who I sponsored 16 and a half years ago, and he's still with me today, okay? So very valuable employee of our team. Employers can also strengthen their long-term workforce strategy by supporting local graduates through the professional year program for international graduates. There is a large pool of people available in Australia who are graduating here from universities. I know sometimes there are pushbacks, because some area, some industry are not as highly skilled as maybe overseas candidates, as I said before. But I think there is a huge pool of local graduates who you can access, and you can maybe train them up. And there is also a training visa available, but that's another topic, So different options to secure a good workforce. Next slide, DJ, please. Okay. Compliance checklist. Okay. Ensure that your SBS is valid. Very important, the standard business sponsorship or the labor agreement. Okay. They're valid for 5 years. Always check. Because if those agreements expiring during a nomination, then your nomination will be refused. Okay. Review the sponsored employee status. Okay, very important that when you're engaging employees from overseas, you check their visa status and check their work rights. Many employees, we had a call from a client at a company whose employees went overseas, have been on holidays, came back, the department has questioned them at the airport, and they find out that those employees were working full-time despite they had the work rights for only 24 hours a week. Now, the employer did not check their visa status, but then the employees were returned back to their home country. So it can have very serious effect and implication on you as an employer or on a visa applicant, okay? So just make sure that you always check. You just need that passport copy and you do your Vivo check, okay? Make sure that the nominated occupation is aligned with your business, and when they do the work, they do the duties what prescribed in an employment contract. Little flexibility if someone gets sick and you want that employee who is sponsored to help out. There is not, the court says if you do 30-40% of the main duties of an employed visa, then you're meeting the requirements, but you really don't want to go to the court. So don't just start employing them in a different occupation. But if they need to help out, there is no issue with that, okay? Ongoing actions, monitoring obligations, okay? So make sure on the department's website you find all the obligations for the standard sponsorships, and seek advice certainly from professional, okay? It's very, very important because the law keeps changing, okay? Next slide, DJ. Now, as you can see, we're coming to the end of the conversation, or my presentation rather, okay? And expert guidance matters for employers. So if you wouldn't mind, take a copy of the QR code, and you can reach us anytime if you have any questions. I mean, any questions, we are here to support you and your business to be successful with the Department of Home Affairs. Right. Next slide, DJ. So thank you so much for attending. And I think we have a question and answer session. So if you have any question about what I shared with you today, please just reach out, and EJ will moderate the questions and answers.
Thank you, Agnes. We do have one question at the moment. So for those who have tailored questions, you can also leave them in the chat or in the Q&A segment. There, we have one from Mates Manpower Agency. Their question is, in terms of work experience, is there a difference if the experience is outside Australia or onshore?
Good question. Work experience can be anywhere, long as it's paid and payment can be verified. So they might lodge their tax return, they have superannuation account, I mean, so many countries has their retirement fund where they're contributing. Bank statement, which shows the transactions that they received the fund from the employer. And certainly employment can be anywhere in the world, okay, Australia and overseas, and can be part-time, as I mentioned, but equivalent. So if someone requires under the new rule 1 year full-time experience for the 482 visa stream, that is, after the qualification, all right, that has to be approved, and can be in Australia, can be in overseas, no problem. EJ, any other question?
None so far, Agnes.
Okay.
We do have one follow-up. Can they have part-time and full-time experience and combine them?
Absolutely. Absolutely. So if someone has, say, 6 months full-time experience and 1 year part-time, that's adding up to 1 year full-time. Okay. 6 months full-time plus 1 year part-time. Okay. Thank you so much.
Thank you, Agnes. I believe that's the only questions we have.
That's
So for
fine.
those who have a more complicated question or a different situation, feel free to scan our QR code and book a complimentary one-on-one consultation with Agnes or any of our expert migration lawyers.
Thank you so much for everybody. I wish you all the very best and good luck with finding overseas candidates. Bye-bye for now.